Yes, Ms. Colwell.
My Lord, just for your note, I left off describing the category of appeals that are considered in the UTJ post 2014 and the numbers asylum and human rights appeals. The sections of the 2002 Act which define or give the right of appeal are tabs 12 and 13, pages 39 and 41 of the bundle, sections 82 and 84. So you can see where the statutory power is. Could I ask you next to look at Sengupta and Holmes, which is at tab 49, page 1251. This, as you may be well aware, is a case about whether a judge who had heard and refused permission on the papers could sit on the oral renewal. And in the course of deciding whether that gave an appearance of bias, the court made a number of important observations about the role of oral argument in the adversarial system. It's at page 38, page 1270. And the court was considering what the fair-minded and informed observer would think of oral argument, and said this: he would know of the central place accorded to oral argument in our common law adversarial system. This, I think, is important because oral argument is perhaps the most powerful force there is in our legal process to promote a change of mind by a judge. The fact that that judges in fact change their minds under the influence of oral argument is not an arcane feature of the system, it's at the centre of it. Knowledge of it should, in my judgment, be attributed to the fair-minded and informed observer. Otherwise, the test for apparent bias is too far distant from reality. It's a commonplace for a hearing to start with a clear expression of view by the judge or judges, which may strongly favour one side. It would not cross the mind of the counsel on the other side then to suggest that the judge should recuse himself. That's Lord Justice Laws. And Lord Justice Keane says the following at paragraph 47 over the page. 1272. One important factor which exists both at a renewed application hearing and at a substantive appeal hearing is the benefit enjoyed by the court of listening to oral argument. This is a fundamental part of our system of justice, and it's a process which, as a matter of common experience, can be markedly more effective than written argument. It will be evident from what I've said earlier in this judgment that before hearing oral argument in this case, I had considerable sympathy for the applicant's arguments. The process of oral debate has persuaded me those arguments are unsound. I mention this simply as one example of the impact which oral submissions may have under our system on the decision-making process. So there's no doubt of the acceptance that oral argument can change judges' minds and inevitably can promote a greater chance of reaching the right result. And in an area where the issues are at stake are so stark, that is a very important factor in favour of an oral hearing. And I want to emphasise again that these are not only cases which concern matters of great importance to individuals, but also they are substantive hearings following a conclusion that there's an arguable error of law. The right to an oral hearing is an established aspect of procedural fairness, which has been explored in two important cases. First of all, Smith. Could I ask you to look at Smith at tab 46, page 1157. West, Smith and West. Both of these cases that I'm about to show you, Smith and West and then Osborne, concerned parole board hearings, but they express general principles about the right to fairness and when an oral hearing is required that extend way beyond that particular context. And you'll see at page 1167 that at the bottom of that page, Mr. Panic, on behalf of the parole board, relied on the statutory context, saying that an oral hearing was permitted but not required. But the court, Lord Bingham, pointed out that the maxim expressio unius exclusio ulterius can seldom, if ever, be enough to exclude the common law rules of natural justice. And then he said over the page, paragraph 30, in considering what procedural fairness in the present context requires, account must first be taken of the interests at stake. On the one side is the safety of the public, which the parole board cannot gamble. On the other is the prisoner's freedom. This is conditional and to that extent precarious freedom. But he says at the end of that, at the end of that paragraph, that despite that conditional right, it's nonetheless a right, breach of which gives rise to an enforceable right of address. So even in a case where the issue, in my respectful submission, is the matter at stake is of less significance than in asylum cases and cases, for example, concerning the splitting of families, which many of the Article 8 cases concern in the tribunal, and it is a conditional right to parole, someone who's been convicted of a crime, and the issue is, it's not whether he goes to prison at all, but whether he is released on parole. Even in that situation, the interests at stake are an important factor in favour of an oral hearing. And then at paragraph 31, Lord Bingham addresses the argument that had been made, which was, and accepted by the Court of Appeal, but which was overturned in the in the House of Lords, that an oral hearing was necessary only when, or required only when facts were an issue which might affect the outcome. And what he said was, while an oral hearing is most obviously necessary to achieve a just decision in a case where facts are an issue which may affect the outcome, there are other cases in which an oral hearing may well contribute to achieving a just decision. And he then quotes from the case of Goldberg and Kelly. If I could just ask you to read that extract. Moreover, written submissions do not afford the flexibility of oral presentations.
In 1970.
Yes, the 1970, but obviously this is a 2005 House of Lords decision applying it.
That's nearly 20 years ago.
Yes. Yes, my lord. Well, I'm going to come to its endorsement in Osborne in a moment, which is more recent than that. And he goes on to explain in paragraph 35, the common law duty of procedural fairness does not, in my opinion, require the board to hold an oral hearing in every case where a determinate sentence prisoner resists recall if he does not decline the offer of such a hearing. But I do not think the duty is as constricted as has hitherto been held and assumed. Even if important facts are not in dispute, they may be open to explanation or mitigation, or may lose some of their significance in the light of other facts. While the board's task certainly is to assess risk, it may well be greatly assisted in discharging it one way or another by exposure to the prisoner or the questioning of those who've dealt with him. And then at the end, it may often be very difficult to address effective representations without knowing the points which are troubling the decision maker. The prisoner should have the benefit of a procedure which fairly reflects on the facts of his particular case, the importance of what is at stake for him as for society. Osborne is at tab 31, 619. This is 2014, or 2013 actually, the hearing.
Which divider?
It's at 619, tab 31.
Thank you.
Osborne applies, you can see in the head note, West. And it's essentially a matter that, a similar issue that was considered in West, but has come back, Smith and West, has come back to the court because a new problem has arisen. Effectively, after Smith and West, the parole board started having more oral hearings, but then they changed their process again, and I'm paraphrasing heavily, but the number of oral hearings decreased, and as a result, the matter came back before the Supreme Court about the correct approach to when an oral hearing was required. So you can see in the head note at 620 that West is applied, and then a paragraph 2, the summary of the factors where it could be said, although not an exhaustive list, an oral hearing would be necessary. And that was the application of the principles in the parole board context. So I rely on that summary in the head note, but what I'd like to take you to is the parts of the judgment itself. So it's Lord Reed, and at paragraph 64,
Page, please.
so sorry, it's page 652.
Thank you.
Procedural fairness at common law, 3 preliminary matters. He first addresses what the role of the court is when considering whether a fair procedure is followed, and he rejects the dicta which might be read as suggesting, you can see this at H at the bottom, as, the question of whether procedural fairness requires an oral hearing is a matter of judgment, reviewable only on Wednesday grounds. It's not correct. The court must determine for itself whether a fair procedure is followed. Its function is not merely to review the reasonableness of the decision-maker's judgment of what fairness required. Now that's important because that's exactly what they did in EP Albania. They did not assess for themselves in the cases before them what fairness required. They reviewed the decision, the reasons of the decision-maker. That's one of the many criticisms of that judgment that is made in the subsequent appeals. At 66, the second matter to be clarified concerns the purpose of procedural fairness. In the case of the appellant Osborne, Mr. Justice Langstaff stated that in determining whether an oral hearing was necessary, what fell to be considered was the extent to which an oral hearing would guarantee better decision-making in terms of the uncovering of facts, the resolution of issues, and the concerns of the decision-maker, due consideration being given to the interests at stake. In the Court of Appeal, Lord Justice Carnworth interpreted Lord Bingham's speech in West as implying that the underlying rationale of procedural fairness at common law was one in which the emphasis is on the utility of the oral procedure in assisting in the resolution of the issues before the decision maker. So that was what the Court of Appeal had found, and the court then went on to consider whether that was correct, and essentially found that it wasn't. There is no doubt, and perhaps I could ask you just to read 67 rather than me reading it out, to 71. So, my lord, the essential point there is that the reference to Biles, Mr. Justice Biles' citation in Cooper and Wandsworth, referring back to Mr. Justice Fortescue about the opportunity that God gave Adam to make his defence, even though he was omniscient, explains at the bottom, is emphasising the requirement for an oral hearing for the purpose of respecting the dignity of the individual. So in other words, even where it's not going to make a difference, even where there is no utility in terms of the decision making, none at all, an oral hearing can be required as a matter of fairness. Now, in my submission, that is obviously not the case in GAs. You've heard my submissions about GA's facts, and it's very unlikely to arise in any of these decisions because the matters that because exactly the points that are made by Lord Justice Laws and Lord Justice Keane and Sen Gupta and Holmes, it's very likely that in an error of law case you would be able to make a difference by making oral submissions. But the point is that the importance of the issue to the individual themselves and the need for dignity can on its own require an oral hearing.
Now, Ms. Kilburn, talking about oral submissions.
Yes, how long?
Yes. You've already overrun your oral submissions by 20 minutes.
Yes.
I'm assuming you're going to finish at 2:30.
Well, I've spoken to my learned friend, and what I was proposing to do, given the issues that have come up, this is Mr. Lee, is go till 3 o'clock.
Taking that from Mr. Lee.
Taking that from Mr. Lee.
Taking that at least in part from my reply, which I think will not need to be as long as we predicted.
Okay.
But it may be that I can finish before 3 o'clock, but that's the provisional arrangement that we have made between us, and I hope that that's all is satisfactory to the court. So that is
you're all aware that we have to rise at 4:15 both days.
Yes.
Yeah.
Yes. Well, we didn't need the half an hour for the preliminary matters, so hopefully that will be redistributed. That is what was said in Osborne, and that is what the judge in JCWI, Mr. Justice Fordham, relied on when he concluded. And I'm going to come back briefly to so you can see how this fits into the presidential guidance note, what was said about the role of importance in the presidential guidance note. But he concluded that the guidance on that issue was erroneous in law because it conflicted with what was said in Osborne. And he goes on at 73 onwards to deal with West, and at 74 emphasises the finding in the passage that I just referred to about the duty to afford an oral hearing therefore exists where there are facts in dispute which may affect the outcome, but it's not confined to such circumstances, and then summarises the paragraph 35 that I also alluded to, and he then goes on at paragraph 79 to emphasise what happened in those particular cases, and I should highlight there that there was a conclusion in a case where an oral hearing, the appellant Smith had not requested an oral hearing, but the House of Lords nonetheless held that such a hearing should have been offered. So it's not a good reason not to afford someone a hearing just because they didn't ask for one, and that's relevant to some of the cases, although not GAs. And then a summary is the application of those principles. There is then the application of those principles, which is what you have in the head note in the parole board context at 80 onwards. And there are a wide range of circumstances in which hearings will be required, but not confined to when facts are important that need to be in dispute, or whether it will make a difference. And also emphasising that it doesn't, at paragraph 88, depend on success. So that is Osborne. And the reasoning in Osborne about utility is picked up in Hussain in the Supreme Court in 2020, which is at 307, tab 20. Now, just to be clear, Hussain is an immigration case, but about a non-human rights issue. It's about the point-based system, and even though fundamental rights of the type that you have in UTF were not at stake, the court nonetheless emphasised the importance of procedural fairness. And in the course of its examination of the issue of fairness in that context, it addressed the important question of utility. Value served by procedural fairness, this is at 322, paragraph 48. In Osborne, Lord Reid considered the value served by the requirements about procedural fairness, and he mentioned three in particular, and we've looked at those. So intuitive expectations of a just process at paragraph 50, congruence between decision making and the law, and she emphasises, Lady Justice Arden, that Lady Arden, I apologise, procedural fairness is thus an important matter. It makes the law more just and at the same time improves the standards with which decision makers are expected to comply in the 21st century. And then the court goes on to confirm paragraph 126 after the heading at 338, so the duty of procedural fairness, the issue of pointlessness. And Lord Kerr and Lady Black asked the question, and this is the majority view: is the duty to act fairly by giving notice of
paragraph?
paragraph 118. I do apologise. Paragraph 118. Under the heading, the duty of procedural fairness, issue of pointlessness. Is the duty to act fairly by giving notice of an impending adverse decision dependent on the existence of the possibility of submissions by the person affected, bringing about a change of mind by the decision maker? And they go on to explain at 120, ample authority, the issue of whether the duty arises when any representations are bound to fail. There's then reference to a number of authorities at 124 to AF3. AF number 3, Lord Hoffman noted the purpose of the Audi Alteram Partem rule is not merely to improve the chances of the tribunal reaching the right decision, but to avoid the subjective sense of injustice which an accused may feel if he knows the tribunal relied upon material which he was not told. And in Osborne, Lord Reid endorsed a normative understanding of the duty to act procedurally fairly. And then they go on to quote various works on how an outcomes-oriented view overlooks the much wider role played by procedural fairness in administrative state. This is a quotation at paragraph 125. And they say they serve as a useful reminder that utility is not the only yardstick by which to measure the duty to act fairly in communicating to an individual why, and more relevantly in this case, when a decision adverse to their interests has been taken. passages in Osborne and the relationship with utility and procedural fairness, and and in particular that there is the link is broken. It's not the only basis on which procedural fairness can require a step to be taken, whether it's oral hearing or representation is being made as utility, is confirmed by Pathan in the Supreme Court. Now, in my respectful submission, what that means in the context of UTJ and the appeals of the category that we've been looking at, what all of that case law means is that the importance of the case and the outcome to the individual and the need for the highest standards of fairness and the possibility that oral submissions are going to likely to have, or at least have the potential of making a difference. Put all of that together, you get to a situation where a norm, or either in practice or as a matter of guidance, that that there should be paper hearings in this context is unlawful, and that it's likely that in asylum cases, very likely that in asylum cases and any other protection cases, and fundamental human rights cases involving matters of extreme importance, an oral hearing will be required. And I just want to go back at this point to look at what the PGN said about this. As I showed you paragraph 9.
So, of what?
This is at page 6 of the authorities bundle.
So you had some initials I didn't understand. The what?
Sorry, it's the President's Guidance again. It's my
The President's Guidance.
The President's Guidance. It's at page 6 of the authorities bundle.
Mm-hmm.
And I showed you paragraph 9, which begins with paragraph 4 of the practice direction, provides that during a pandemic, decisions should usually be made in this way. In other words, under Rule 34 without a hearing, that's what paragraph 9 says. And there is then at paragraphs 10 onwards a set of procedural directions. So this is what you saw happened in Upper Tribunal Judge Bruce. Examine on the papers where permission has been granted, and will consider whether in all the circumstances it's his provisional view that it should be, the error of law hearing should be on the papers. Then at paragraph 12, directions. And then the process described will include a direction to enable them to express their views on whether there should be a hearing. And then at paragraph 14, in formulating the process, UTJ is drawing on its expertise since 2010 in making error of law decisions and decisions on whether in the light of a finding an error of law, the first tier tribunal's decision should be set aside. It's unusual for the questions, paragraphs 11A and B above, to require oral evidence or findings of fact by UTJ, but if that's the position, the judge may decide a hearing is necessary. The presence of particularly complex or novel and important issues of law may also be such as to necessitate a hearing. So identifying a threshold there in which a hearing may be necessary. And then at 15, the judge can also be expected to have regard to whether a party is unrepresented. In deciding whether it's necessary, it's important to appreciate the fact a party is unrepresented will not necessarily lead the judge to conclude a hearing is necessary. It might be easier with someone with no limited English language to make their submissions in writing with the assistance of a relative, friend or other party rather than to address the UTJ orally. Here as elsewhere, the judge will have regard to all relevant circumstances. And then at 16, in deciding whether it's necessary to hold a hearing, the judge can be expected to have regard to paragraph 4 of the practice direction, Rule 2 of the UT rules. The fact that the outcome of the appeal is of importance to a party or another person will not, without more, constitute a reason to convene a hearing to decide the relevant questions. Almost all appeals in the immigration jurisdiction are important to the individuals affected and to the Secretary of State in the discharge of her statutory responsibilities. In particular, human rights and protection appeals necessarily involve the prospect of an individual being removed from the United Kingdom. And so what Mr. Justice Fordham concluded in relation to that paragraph is that it was wrong in law by reference to the case law that I've just shown you about in Osborne and West, because the interests of the individual could alone be a reason for having an oral hearing. And he also found that when all of the guidance was read together...
Where did he say? So he said that paragraph was unlawful, including the reference to paragraph 4 of this senior president's guidance.
He said that the suggestion that the importance of the case without more would not be a reason for an oral hearing was unlawful. It's an error of law.
Where?
That is at 7.1 to 7.6.
Sorry, say it again. 7.1
to 7.6.
Sorry, may I have the page number?
It's at 292 to 293. Apologies. In fact, 294. He doesn't say that it's unlawful to refer to paragraph 4 of the practice direction. He says it's unlawful to direct that the importance of the case without more will not necessitate an oral hearing. Because in fact, the importance of the case can alone necessitate an oral hearing. And that's confirmed in Osborne. And he explains his reasoning at 7.1 to 7.6. And you'll see that in fact, by the conclusion of that hearing, the President had conceded that in a mainstream contentious non-obvious case, an individual, it just as a result of those features, that could be a reason to have an oral hearing. And in the light of that concession, partly in the light of that concession, the suggestion that something more was required was wrong. But he also went further than that and said that even where it could be said to be obvious, this is at 7.4, that that would still not necessarily mean that an oral hearing was not required. So the reasoning is detailed, and for the reasons I've already explained, I wasn't proposing to go through it to defend it, because it's not being challenged. Or at least it wasn't.
Well, it's being challenged insofar as it may be inconsistent with EP.
Well, my lord, in EP, as I've already explained, I mean, we perhaps need to look at EP. EP does not set out different principles of law. EP applies and takes an approach to analysing 18 different cases, individual cases. Now, the outcome of those decisions is maybe, and this will be a matter to be considered in those decisions, inconsistent with this reasoning. It may well be. But it doesn't purport to do anything close to making the analysis that is contained in this judgment. There is one passage in EP Albania, in the middle of one of the cases where the tribunal says that Osborne is not relevant or is of little relevance because it concerns parole board hearings. Now, that in my submission is as far as it goes, and it's obviously wrong because Osborne sets out principles of law that have been applied in a range of different contexts by the Supreme Court since. So to suggest that it is confined to the parole board context is obviously wrong. So that is the reasoning on importance, and it's the interpretation of paragraphs 9 to 16 and 17, which mean that the tribunal, that the court ultimately concludes that there is first of all, it communicates an overall paper norm, and secondly, that the guidance in relation to the relevance of importance is erroneous in law. And in my respectful submission, that latter finding in particular is obviously correct. And I've just taken you to Osborne, which says so in terms. Utility is not a sufficient answer. It is not lawful to require utility in all cases. My Lord, JCWI, just turning back to it, and the interpretation section, it's at 269 of the bundle, the approach to interpreting the PGN. And I just want to briefly show you what the exercise of, I'm not in the process of defending it for all the reasons set out, but just to show you the exercise of this one. So at 269, at 4.2, there was no material dispute between the parties about the approach which this court should take to interpreting the President's guidance. It comes to this, it's to be read and interpreted objectively and straightforwardly as a whole in the light of its function and purpose, and having always in mind that it was directed in its application to an audience of UTJ judges, I adopt that approach. And then he acknowledges the sections that we looked at, the reference to the senior president's direction, the overriding objective, and he accepts at the bottom of that paragraph that paragraph 4 of the practice direction is quoted, then Rule 34. He says, nobody least of all a switched on UTJ judge could miss the proviso within paragraph 4, says Mr. O'Brien, because it's set out there in paragraph 7 of the President's guidance, nor could they miss the link to the overriding objective within the proviso or its central significance. I accept all of this. He then goes on at section D. Section D is the operative section on hearings and paper determinations. Having said all of this, there's no mistaking that it is section D which contains the operative paragraphs, headed making certain appeals without a hearing. So far as guidance on UTJ judges deciding cases without a hearing, pursuant to Rule 34 and paragraph 4 of the Senior President's Practice Direction, Mr. O'Brien accepts that. So it is section D which delivers, so far as paragraph 4 of the Practice Direction and Rule 4 are concerned, the function which was seen in the guidance. No, the President's guidance, this guidance explains what will happen with regard to the cases which are before UTJ during the pandemic. It's important, moreover, to recall that this is in the nature of guidance on changes in the law and practice as they relate to the functions allocated to the Chamber under the statutory function being exercised by the defendant. And that statutory function is set out at paragraph 242 in the judgment. The operative section, which should say section D, is where the audience of UTJ judges can expect to find the guidance on what PPD4 means for us. And he then goes through and explains why, first of all, what the first paragraph and we looked at this sentence, decisions should usually be made in this way. That's what it says. He then deals with arguments that Mr. O'Brien made about that and why effectively what it means is it's communicating, this is halfway through, it's 4.62. This is where this is where the PGN, the guidance is read and understood as communicating guidance on the change in the law and practice, which tells the UTJ judges what the senior president's practice direction means for the work of the UTJ during the pandemic. Decisions should usually be made without a hearing, whether it's based on interpretation or application. It could indeed be received as correct when nobody has lost sight of the proviso. So in other words, they know about the proviso. This is the point you put to me, my lord, earlier. They know about the proviso, but they understand it as meaning in this context, applying the overriding objective to these types of hearings, that you have a default position in favour of paper hearings. Paragraph 9 is telling UTJ judges what the practice direction means to us. And then another argument is made, it's a preamble, he rejects that. He then goes on to deal with the rest of section D, and he accepts that it must be read as a whole, and he goes on to examine all the other parts that I've shown you, fact, law, and importance. Accepting all along that judges can be expected to have regard to paragraph 4 of practice direction rule 2 of the upper tribunal rules, which is the overriding objective, and he analyses the effect of the reference to finding the need having oral hearings where there are findings of fact or oral evidence, particularly complex and novel importance, such as to necessitate, then the guidance on the importance, and he says at 4.12, in my judgment, even leaving aside paragraph 9, whether treating it as a preamble or reading it as impliedly repeating the proviso, or as containing an obvious mistake, and keeping well in mind that PGN 16 says the judge should have regard to paragraph 4 of the practice direction, rule 2 of the UT rules, the operative guidance section takes 3 key topics of fact, law, and importance and communicates that each of them is not of itself a reason normally to have a hearing in the application of that senior president's practice direction, rule 34, and the overriding objective. It's a powerful message in relation to each. It's a yet more powerful message in combination. And then he says at paragraph 413, there's a final point on what section D communicates. It concerns what section D does not say. There's no counterbalancing message. There's no identification of a fact or even a combination of factors which will regularly be encountered, which would support having a hearing. There's nothing which communicates that the UTJ judge would or may well conclude that the correct understanding of PPD4, that's the senior president's direction, involves having a hearing in a typical UTJ substantive appeal. And for those reasons, he concludes reading and interpreting the PGN objectively and straightforwardly in the light of its function and purpose, and having always in mind it was directed in application to an audience of UTJ judges, that it does communicate a paper norm. And I've already shown you the external aids to interpretation, which he rejected, the arguments that I made. And then at 275, he asks whether it's saved by the audience.
And I imagine the answer to that is if you go through each individual one, you'll work it out as they did in EP Albania.
Yes. Well, exactly. What he says is...
I mean, he obviously had to take an overall view for the purposes of declaring it lawful or unlawful.
Yes.
And our task in these two cases is to look critically at the decision in your two cases. And in EP Albania, if what they were doing was looking critically at all those cases, then that's fine. Because that's what you've got to do, is work out what the judges, the audience, did. I mean, otherwise you would just, because there's the striking down on a generality.
Yes.
And then looking with the particularity of a particular case.
Well, I accept that. I accept that when you look at whether a correct decision has been taken, whether the unlawful guidance has been followed, you look at the individual case. I don't for a minute seek to dispute that. The only thing I'm taking issue with my learned friend and the Secretary of State on is being is the suggestion that this decision is wrong in relation to the guidance.
No, I understand that.
But when it comes to the individual case, what he says here is it's not enough, that it might be saved by the audience. He explains here, and this is relevant to EP Albania, because what he does do is he explains why it is that judges could be expected to follow this guidance. And he also explains, and this is the point that I made earlier in answer to my Lord Master of the Rolls' question about the expertise of judges, regular expertise of judges in assessing fairness, that this is not an area in which they are experienced. Indeed, any judge in this oral adversarial tradition is experienced in deciding when it's fair to dispense with an oral hearing. And just the very fact that there's been this level of argument about it in the High Court, and even now, suggests that it is not an entirely straightforward issue, as does the fact that Osborne and West both went to the House of Lords, and in both cases, the Court of Appeal's approach was overturned. So these are not, in my respectful submission, straightforward issues. It's a difficult question, and particularly where you have a brand new process introduced in a pandemic, and decisions are having to be taken quickly. So the guidance was meant to be followed. It was directed to judges who were not normally having to take those types of decisions, who had for decades always held oral hearings, and were now being asked to consider something different as a result of the pandemic. So that's what he says at 4.19. And then at 4.21, he talks about the impact evidence, and he again discounts it in deciding what the guidance note actually communicated. He discounts the impact evidence, but he says, and you can see that at 4.2, the true legal import of impact evidence goes to the issues which arise after the objective meaning of the guidance note has been identified. The first is to whether any error of law in the guidance is to be characterised as material, and then as to whether you should have a remedy. And he concludes that it is material because 2/3 of the determinations, he explains the figures, were on the papers as a result. And that is inconsistent with the concession of the President and of his conclusions at Section 6, that you couldn't have that number of paper hearings in this jurisdiction because of the issues at stake. So it was material, but he doesn't rely on that when deciding whether the guidance itself is unlawful. So, my Lord, EP Albania, very, very briefly on EP Albania. The tribunal's central conclusion in that case, and I've dealt with it in the skeleton argument, was that the inference could not be drawn in any of those cases that the guidance note had been followed. I just want to emphasise that there's been some sort of raised eyebrows about the Secretary of State saying they should all be set aside unless it was inevitable, all those applications, unless it was inevitable that the result would have been the same. That was the Secretary of State's position in front of the tribunal in EP Albania. Now that was because everyone, until the morning of the hearing, had assumed that the judges were following this guidance. No one had ever suggested that they weren't following the guidance. And indeed, there is the injunction decision in JCWI, because an injunction was sought to stop these determinations going ahead pending the challenge in JCWI. The refusal of the injunction, its premise was that it was making a difference. And I would like to just draw that to your attention. The injunction judgment is in the supplementary.
Well, that would inevitably mean that a judge's best attempt to work out what was likely to be happening, because of course the judge would not be in the UT Act determining what was happening in practice.
Well, that's right, but I'm just explaining that it was the working assumption of everybody involved that the judges were following the guidance, as they were intended to do by Parliament and by the President himself. I mean, why would he have produced the guidance if it wasn't expecting people to follow it? It was there to be followed. And there was no indication in any of the decisions in front of EP Albania that it hadn't been followed. There was no one saying, I've decided actually I'm going to take a different approach. And so it's just for your note, it's at tab 4 of the supplementary bundle, and the relevant paragraphs are at 22 onwards, 22 to 25. This is 229. And first of all, I want to emphasise that the point was made that the consequence of not granting an injunction was that the backlog of appeals would be, as I put it then, shunted off to the Court of Appeal. That was the point that was made. If an injunction wasn't granted and JCWI was successful, then on the balance of convenience, it was JCWI's submission that the balance lay in favour of granting the injunction, so that there wouldn't be a need to re-examine all these cases in the Court of Appeal. Now, in rejecting that argument, there are 2 points to make about paragraph 23. First of all, the judge assumes it will have an impact. If we suspend the application of this guidance, she said it's likely to lead to an even greater backlog in the tribunal than the one that already exists. And then she says the balance of convenience comes down very firmly in favour of denying interim relief. Because she gives a number of reasons for that, including that some applicants may get favourable decisions. And she then accepts at paragraph 24, if the procedure turns out to be unfair, I accept that then there may need to be reconsideration of those appeals, but that would only happen, of course, if someone lost. No one's going to complain about the fact they've won. And my Lord, I do. So first of all, it shows that it was expected that it would make a difference, that it would be followed. And secondly, it shows, and that it would be followed with a view to having paper determinations. And secondly, and that wasn't disputed by the President, I should say. And secondly, it shows that the convenience angle, and I do say this is important, it shouldn't be held against those who are bringing these applications now, or bringing their appeals twice. A decision was made, a conscious risk was taken that if the guidance was found to be unlawful, appeals would have to be brought to correct any unfairness. And so the fact that, if it is the case, that many have to be set aside is not a reason. The inconvenience to the tribunal and the court system of that occurring is not a reason not to grant the appeals or allow the appeals in my submission. It would be unfair if the convenience angle were taken against appellants twice. So the principal conclusion, just turning back to EP Albania, was that they looked at the individual cases and said that, inferring without any express reasoning, that they hadn't followed the guidance. And it was on the basis of those inferences, that they hadn't followed the guidance, that they then went on to examine whether they'd applied, reached a fair decision to dispense with an oral hearing otherwise. Now, I should say that in each and every case, and I can give you a paragraph, it's a very long judgment, but I can give you relevant paragraph numbers if you want. As I say, this case, the decisions in these cases are not before you. They actually went on to conclude that the decision was lawful on a review, basically a review basis. We can't see anything wrong with the reasoning of the judge in dispensing with the oral hearing, rather than looking at the decision for themselves and deciding whether it was fair. And so you'll, as I say, I can give you paragraph numbers for each of the 18 cases if you want to try and go through the judgment, or I can write them in a small note. It might be more convenient.
Is that an entirely fair description? I mean, there was one where they looked at it and they said, look, we can see that something went wrong procedurally, even though the reasoning, so it rather looks as if they were engaging themselves on whether it was fair or not.
Well, there were two cases cases where they said that something had gone wrong procedurally other than the decision to hold an oral hearing. So in other words, it wasn't about whether it was fair not to hold an oral hearing. It was about some other aspect of unfairness.
I think my Lord's point is different. I think
Yes.
His Lordship is suggesting that the exercise that the judges were engaged upon was not simply a review. They were looking to see if the decision was fair.
Yes, I accept that they looked at whether it was fair. There were some other aspects. They identified whether there were other aspects of unfairness. But I'm just pointing out that when you look at the reasoning and when they do the twin exercise of inferring whether they followed the PGN, which is the first thing, because they accept in EP Albania that if you followed the PGN, the President's guidance, it would be the decision would be unlawful. They accept that, and it would have to be set aside. So it's a critical question. Did they follow it? They make an inference, and then they go on separately to decide whether the reasoning which is given in each case for dispensing with an oral hearing is sufficient or not. And they approach that question largely on a review basis. There's one case, as far as I recall, where something a little bit more substantive may be said, but on the whole, they say things like, in the circumstances, this reasoning is fine. But they don't assess for themselves whether it's fair or not. And you also can't see from the judgment, they don't quote, on the whole, the decision to dispense with the oral hearing. So you need the underlying determinations in order to assess whether they've taken the right approach or not. And you don't have them, and they're not quoted. So, my Lord, just... my general submission is the one I made at the outset. In my submission on EP Albania, it's not going to assist you to look at EP Albania. The decision is not before you. It's being appealed in other cases which are before the court.
Well, for which permission is sought, which are all stayed, which is why this
Yes.
at least step had to be taken.
Well, I understand that, but those, for example, I don't think the individuals were notified that their cases had been...
nothing's been stayed, but they're all waiting.
They're all waiting, I understand.
We waited for JCWI, we then waited for EP Albania, and then we were told it was going to be decided, then we were told there was another day needed. And then as soon as we got the judgment in EP Albania, we have accelerated these as quickly as we can. But we can't do anything more than decide what's in front of us.
Well, I understand that, but it's just that EP Albania is not... Because these two cases that have been selected are not EP Albania cases, all of the papers and decisions in EP Albania, or even any of them, are not in front of you. That's the simple point that I'm making. I'm not... And the problem with that is that since EP Albania was all about how do we approach individual cases... you then have to look at what was argued, what was decided in individual cases in order to decide whether the right approach was taken. You can't, in my respectful submission, easily do that exercise in the course of these appeals. And I've also already made my submissions about how, this was a different exercise to the one in JCWI, where they were deciding in the ordinary way, from scratch, an application for judicial review, rather than reviewing a decision that had already taken prior to an appeal. But there are a number of criticisms that could be made of EP Albania and that are being made in the subsequent appeals. And those include conclusions like, it wasn't necessary for the judges to set out the factors that the relevant factors that are set out in Section 6 of JCWI. So even though judges, on the whole, were not mentioning importance, were not referring to the relevant case law, were not assessing when an oral hearing was necessary, the court said that it wasn't necessary to set all of that out. And very brief reasoning was upheld. Now, in my respectful submission, can't be right. And indeed, in GA, the Secretary of State has accepted the reasoning as inadequate, for example. And they also said that the failure to refer to Osborne says little about whether the tribunal directed itself properly because it concerned the parole board. Again, that in my submission is an error of law. It wasn't necessary to refer to the overriding objective or the practice direction or leading authority on the common law duty to act fairly. That's paragraphs 50 to 51 of EP Albania. And all of that in my submission is wrong. So it doesn't really assist, in my respectful submission. What assists is to look at the case law that I've taken you to, which is summarised in section 6 of JCWI, and apply it to the individual cases for you to decide whether they were determined lawfully. And of course, in GA's case, because there is such a clear statement that the PGN was, the President's guidance was followed, it's clear that it wasn't decided lawfully. And I think I've probably said enough in the course of my factual opening in relation to GA to explain why I say that applying all that case law, it's obvious that that decision was taken unfairly and unlawfully. It was in.
Well, you're slightly on borrowed time.
Yes, I'm now on borrowed time. So those.
I'm assuming you're borrowing time
from Mr. Lee.
from Mr. Lee still.
I will stop because those are my submissions, and unless there's anything further which I doubt.
No, thank you.
Thank you very much.
Thank you very much.
Mr. Lee.
I'm grateful, my lord.
Sorry,
I'm
just
grateful.
before you begin, I've just lost the reference to EP Albania, the page number.
Oh, EP Albania.
Sorry, just
It's at tab 16 of the
fine, thank you.
of the
I can
authorities
find
of
it from
London.
there, that's fine. So I had it on my screen, I lost it. Thank you.
No, this isn't actually.
Apologies,
It's
Miss
tab
Lee.
17. Tab 17, page 159.
I'm grateful, my lord. I'm also grateful to my learned friend for setting out much of what I would have covered had I been on my own. So the first thing I should say is I adopt my learned friend's submissions with regard to both the correctness of JCWI and its relationship to EP Albania. I don't think I need to say anything at all with regard to the correctness of JCWI at this stage, but I will very briefly, because my case is slightly different from my learned friends in respect to the respondent's position. I will need to say something, I think, about EP Albania just at the end of my submission. The structure, my lord, I propose to follow just to take 5 brief stages. The first is to very briefly set out the facts of Mr. Hussein's case. The second is to spend a bit of time. I think it is necessary to delve somewhat forensically into the procedure that was followed in his case, because it does inform both the substantive errors of law that we say exist, but also the effect of not holding an oral hearing in the individual case, which in my submission is relevant to my lord and my lady's assessment of the overall fairness of the case. And I'll also deal with what we say went wrong specifically in the procedure. And then lastly, briefly, I hope, an application of the learning to the facts of the case. And finally, my brief submissions on the effect of the presidential guidance note in light of JCWI, and some submissions on EP Albania, confined to what I say should happen in this individual case, so what the effect essentially of the errors of law should be. This was, my lord, as you'll see from the paper, this was not a protection case. This was a application by the appellant for a residence card pursuant to the EEA regulations and free movement rights under what was the 2016 regulation. He applied on the basis that he was dependent on his uncle and therefore had a right to enter and stay in the United Kingdom as a result of that. The feature of the case that framed his submission to the first tier tribunal was that he had a previous appeal in which that judge had identified aspects of the evidence which were lacking. That judge had said there wasn't sufficient evidence of the position in Pakistan prior to the appellant coming to the UK. And so the substance of his new appeal, the appeal that's led to the upper tribunal decision in this case, was directed at the period in Pakistan and an attempt to, what might be called, plug the gaps in the evidence that was before the previous judge. There are three grounds of appeal arising out of what happened subsequently to the first tier tribunal's decision. I've set them out briefly at tab 2 of the core appellants bundle, which I hope my lords and my lady have in Mr. Hussein's case. It might just be worth just looking at them briefly because there's a certain context to this case.
So we're looking at the core appellants bundle.
Yeah, so this is Mr. Hussein's core bundle. Tab 2, page 12. Original grounds of appeal to this court.
Yeah.
Do you have that model? I'm grateful. The three grounds of appeal, these were drafted in October 2020, so prior to JCWI and prior to the Albania. The first, put simply, was that the decision in the individual case to dispense with an oral hearing was an error of law. And the second and the third are both freestanding, but also, in my submission, consequential to a certain extent on the first. And they are that the Judge Hanson, failed to take into account a set of submissions and arguments, which I'll come to, of the 2nd of April 2020. And in ground 3, that he either didn't engage or didn't give proper reasons for rejecting central aspects of the appellant submissions before him. And put simply, although they're freestanding, clearly I'll seek to argue that there's a relationship between the errors that upper tribunal Judge Hanson entered into and the fact that he didn't have the benefit of oral submission. The only other point I would say, just in terms of the framing of the grounds, is that I will be making the point that if an oral hearing is dispensed with in the individual case, there is a strong argument that the duty to give reasons and to engage with each of the submissions that are made in writing, if that's the mode of argument that's adopted, is heightened for reasons that I'll come to. The procedure that was followed in this case really did straddle the beginning of the pandemic. The first tier tribunal decision, which I don't need to take you to yet, was handed down on the 26th of September 2019 for references at tab 14 of the bundle. The grounds for permission to appeal to the upper tribunal were lodged on the 9th of October 2019. And then the grant of permission, which I will take you to, if I may, my lord, is at tab 12, page 84 of the core bundle. That was made on the 28th of February 2020. So, right as things were not quite developed, but beginning to develop in terms of the general awareness of the pandemic.
Not sure we had any idea what was coming to us on that date.
No, that may be right, but this case is an example of a case where permission was granted before any restrictions were put in place, and then there were subsequent directions. I'll just take you to that tab 12, if I may.
Sorry, page.
It's page 88.
Thank you.
I'm sorry, no, it's not. It's page 84. to the grant of permission. The first is the standard direction on the front of the, on page 84 itself. Then over the page is the reasons that have been given by designated first-tier tribunal Judge MacDonald. And just pausing there just to echo the submission that my learned friend made, which is that it is a feature of this jurisdiction that before one gets to argue the error of law, one goes through a gatekeeping system. So there is a designated, experienced, ticketed judge who filters out cases where it's considered that there's no arguable error of law. So one has to get through that before one is then able to argue on any basis that there has been an error. And then notably, my lord, and I raised this simply to give an indication of the procedure that was followed pre-pandemic. The directions are on page 86, and those are essentially the directions that were sent out in certainly anecdotally every case I've ever seen. And there's a couple of features of them. Paragraph 4 is indicative, in my submission, not just of a presumption of a hearing, but of a presumption that the hearing would encompass both the error of law and any remaking of the decision. And that was the position, the default position, if I can risk the shorthand, that the tribunal took at the time. You'll see paragraph 4, there is a presumption that in the event of the tribunal deciding that the decision of the FTT to be set aside as erroneous law, the remaking of the decision will take place at the same hearing. The fresh decision will normally be based on the evidence for the FTT, etc. And then...
Yes, but that, as a matter of practice, that depended on what happened. If you needed further evidence, then directions would be given, there'll be an adjournment and all the rest.
Yes. I think the only point I'm trying to take is firstly that that's clear that there's a presumption in favour of a hearing, full stop. I think all the evidence before JCWI, and it was accepted in JCWI, was that was very much the default position in the vast majority of cases. And that's underlined by the fact that the scope of that hearing was also, the default position for that was also defined. And then, I won't dwell on it, but the paragraphs 6, 7, 8 and 9 are all based on...
Sorry, 6, 7, 8 or 9 and what? I'm looking at the directions now.
Yes, so...
they finish at paragraph 5.
They go over the page, I hope.
Mine doesn't.
Page 87.
Yeah,
I think...
Yeah, okay, I was looking at the one you went back to at 84. This is 89, okay, yeah.
So the paragraphs 6 to 9 are all predicated on their being...
So can I just be clear, are these directions standard? Or I thought you were saying that the one that was at page 84, which included paragraph 4, signed by Mr. Oggleton, was standard? Or are you saying the directions are standard too?
Sorry, I'm talking about page 86. I'm sorry if I didn't make that clear.
Oh, okay.
Page 84 in my bundle is...
You haven't been talking about...
No. Paragraph 86 is the one that's headed directions, with some italics, and then there's another
paragraph. I've been at cross purposes, I'm sorry.
So it's paragraph 4 of that.
Yeah, I've got it now.
And if it helps, I mean, those look fairly standard directions that I looked at when I had to sit in UTAC.
Yes.
We all have to do a spell in UTAC.
Yes, and the only point I was going to make about paragraph 6 to 9 is that all of the directions in terms of the timetable all work off the presumption that there will be a hearing. The next thing in time that happened is that there is then the directions that my lord was looking at page... I have them at page 82 and 83. My lord and I are not...
Yeah, the electronic numbers are different anyway.
So that is the directions from Mr. Vice President Mr. Oggleton, and they're dated the 18th of March. It's a feature of this case that these directions were in fact sent out before both the Senior President Tribunal's practice direction and the Presidential Guidance Note. So this is the 18th of, dated the 18th of March.
So not infected by the unlawfulness that Ms Kilroy says infected the decisions
Not at this stage.
in EP Albania, yeah.
Yeah, so not at this stage. The point I will take is that as the procedure develops, clearly the decisions that Upper Tribunal Judge Hanson takes are in light of the Presidential Guidance Note. But in any event, Mr Oppleton at paragraph 1 says three things. The one, that he's reviewed the file. The second, he notes the need to take precautions. And three, again echoing something my learned friend said about the general approach, that he'd reached a provisional view that the case was suitable for a decision on the papers rather than an oral hearing, but with no substantive reasons as to why that is the case. And those directions envisage, again, similar to the standard directions that would later be issued, those directions envisage sequential submissions from the parties on the area of law, and then separate submissions, if advised, on the question of the mode of disposal of the appeal, so the mode of hearing, and that was to be by the 9th of April. Those directions, in fact, are not exactly the same, but they're similar to the standard directions that were issued following the practice direction and the guidance note. And if I won't turn it up, but they are set out at paragraph 4.17 of JCWI, which is at page 274, tab 19 of the authorities bundle. So that they are very similar, even though they predate the
So the PGN doesn't seem to have had any effect on the standard practice.
Well, no, because the standard practice, we don't know what the standard practice was prior to the.
Well, Mr. Ockleton was the vice president before and after.
Yes, but the amount of directions that were sent out
Increased.
Well, in light of the pandemic, which weren't following the PGN, it was a very, very brief window for obvious reasons, because, as my lord has identified, it was really only that sort of middle of March period where the true extent of the difficulties became clear. So the only point I make in this is that whilst the directions predated the guidance note, everything thereafter that Upper Tribunal Judge Hanson is clearly with a view to the operation.
So can I just be clear? So before the practice note, and you've taken us to it, there was a standard form of direction, and indeed it looks like it's just a template, effectively, that got sent out in each
Yes.
case. And that clearly anticipates an oral hearing. I mean, it's got provision, is it paragraph 8, for an interpreter,
Yes,
for example.
yes.
So we then get the practice note of the guidance, and you telling us, and I was just looking to the reference you took us to, that was that accompanied by some new standard directions?
So as I understand,
Did they come out together?
they either came out together or one followed the other. My learned friend was in JCWI, so she might be the best person to ask. But as I understand it, they were contemporaneous.
But anyway, so the anticipation was that they would supersede any standard directions that had been issued prior to the pandemic.
Yes.
And is that what then happened in this case? The directions you've just taken us to, which are similar but not identical to the new standard directions,
Yes. Yes. I'm sorry about that.
overtook the template directions
Yes.
that had been issued.
So the first set of directions were overridden
Yep.
or superseded by another set of directions that were made in light of the evolving circumstances of the pandemic. So
And that's where you say that your case became, at that stage, became infected, as you would say, by the unlawfulness of the guidance.
Yes, and if there's any doubt about it, Upper Tribunal Judge Hanson makes a series of decisions which make it clear that he's...
Understood. I was just trying to pinpoint the
Yes.
moment in time where you're
Yes.
telling us.
I mean, the only complicating factor in my case is that those original directions come out shortly before the presidential guidance notice promulgated. But of course,
Not as awkward if they come out just after.
well, yes, well, the short point is that the procedure is an ongoing procedure. So one looks at how it starts, but then also how it ends, and then all the bits in between. And in this case, it's possible in my submission to point to difficulties throughout and an end result, which is both procedural and substantially unfair. But this is just really by way of how we get there.
Thank you.
The next thing in time that happens in response to these directions is a set of submissions written by the appellant's counsel in accordance with the first direction at paragraph 2.1. So he drafts a set of submissions dated the 2nd of April, and they are at tab 10, page 73. And they're an important feature of this appeal.
Sorry, page.
Page 73.
Thank you.
The submissions begin at paragraph, well, there's a preamble. Paragraph 3 is a request for an oral hearing in this case. And with the caveat that because the directions have made provision for submission specifically on that point by the 9th of April, that application will likely be amplified. And then at paragraph 4, there's a brief reference to the need for reflexive engagement between the judge and representative in order to afford the appellant a fair opportunity to advance his legal arguments. There is then, the rest of the document essentially is a recasting of the original grounds of appeal, which I will go back to in a moment. But this document is this council recasting the grounds of appeal and making forensic points in light of them, including references to parts of the determination and evidence that wasn't in the grounds of appeal itself. So, pausing there, the sort of thing, or the sort of approach that one might take in oral advocacy. If one's presenting a set of grounds of appeal, you would build on those grounds by pointing to parts of the evidence and parts of the document. And then in my case, it appears that was what counsel had in mind, given the direction that he might not get a normal hearing. The next thing in time was a response to those grounds of submissions by the respondent, again in accordance with the directions, and that's at tab 9, page 66 of the bundle. I needn't take you to those at this stage, but I can deal with any points that my own friend makes about those in reply. And then on the 9th of April, again in accordance with those directions, tab 8, page 62, council makes submissions about the mode of determination and disposal of the appeal, and applies, although it's misspelled, it applies for an adjournment. There are a couple of features of this application which are important. The first is that the primary position of the appellant is that the face-to-face hearing is necessary and required. The second is reference to the ILPA letter that was written to the President, which I'll come to in a moment. And the other is that from paragraphs 4 through to the end of that application, those submissions, is essentially an analysis and a reference to the sorts of common law fairness cases that my learned friend has referred to today and were considered by Mr. Justice Fordham in JCWI about the importance of...
Is it suggesting a face-to-face hearing or a remote hearing, bearing in mind that the 9th of April is deepest lockdown?
Yeah, so the face-to-face hearing encompasses the possibility of a remote hearing.
Where's that?
Well, if I can come back to that, if you forgive me a moment, my lord.
Well, it says in paragraph 3, I think I found it, the appellant's submission is the area of law. Appeal, if not adjourned, should be determined at a
Yes.
hearing conducted remotely.
Yes, so there's two aspects of paragraph 3. One is the request or suggestion that the matter be dealt with remotely, because at that stage that was beginning to happen in this jurisdiction but also in others, and refers to the letter from the Immigration Law Practitioners Association, which might be convenient for me to take you to. That's at tab 21, page 169.
Core bundle.
Yes.
Sorry, page 60.
Page 169 begins, my lord. The part I'm going to begin at is page 170.
I stop at 168.
There was an amendment to the core bundle made by my learned friend for the respondent. So
I'll find it, don't worry.
we have loose copies if
No,
that's...
I can find it, don't worry. Thank you.
Which bit do you want?
Is top of page 100?
Top.
Yes, top of page 100.
Our primary consent.
Yes. So that again is a reflective of the position of the 9th of April submissions. Again, a suggestion that if face-to-face in its classical use of the word isn't possible, then a remote hearing via some form of technology, either by telephone or video link, is the compromise and proportionate response to the situation. And the tenor of the letter is essentially that the worst option, the worst outcome of all of the three possibilities of face-to-face, remote, or on the papers is on the papers, and that's the position of the Practitioners Association. And then finally, my lord, just for completeness, on the penultimate page of that document, it's page 172, but I don't think there's actually a number on that page. The middle paragraph beginning, although it relates to the judicial review application, the second sentence in that paragraph, the importance of oral argument cannot be overstated, permits an advocate to crystallise the key aspects of the case, but crucially permits advocates to engage with and answer the questions of the judge. As such, absent votes for when the paid decision may be inferior. So that's the reference to the ILPA document. In respect of the general provision for remote hearings, it was always possible under the procedurals, even prior to the pandemic, to have a remote hearing in the tribunal for obvious reasons. And indeed, there has been discussions in the higher courts in respect of the questions of appealing from abroad as to the utility of remote hearings, even prior to the difficulties of the last 2 years. But at JCWI, and I think if I may just ask you to turn up JCWI again at this point, it's at tab 19, page 253. paragraph 2.8, which is on page 253 of that authority, sorry, that authority manual. The Upper Tribunal Procedural Rules, Rule 5A, was introduced on the 10th of April 2020, and that introduced essentially an addendum to Rule 34, which allowed disposal of proceedings without a hearing if the Upper Tribunal considered the conditions in paragraph 2 were satisfied, and the three conditions were: the matter was urgent, it's not reasonably practical for there to be a hearing, including a hearing where the proceedings would be conducted wholly or partly as video proceedings or audio proceedings, and see it's in the interest of justice to do so. Hence the, well, that's not hence, but consistent with the submissions based in the 9th of April and by ILPA. The on the just for fairness, my learned friend asked that the response to that ILPA letter by the President was put in. That is at tab 22, page 174. I don't intend to take my lord to it at this stage. Again, if anything arises, I can deal with it in reply. The going back to the submissions of the 9th of April, so back to tab 8 of the call bundle, page 62. I just wanted to just highlight again paragraph 11. This is page 64. There is little reason against using technology. Both paragraph 10, the instant case would undoubtedly benefit from these features of oral argument. This suggests that an oral hearing should take place unless there are sufficient countervailing reasons against it. There's little reason against using technology to provide for remote hearing. Telephone and video hearings can be accommodated relatively easily. At the expense, they are occurring regularly during this emergency in other areas of the justice system, e.g. the Administrative Court and Court of Appeal, and the Upper Tribunal. On the 16th of April, and this is at tab 7, page 51, the appellant made submissions in reply to the respondent submissions of the 3rd of April. And again, I needn't take you to those at this stage, but they are in the form of a response to the individual points made by the respondent. On the 1st of May, again, this is an important feature of the issues that arise in this appeal. This is at tab 6, page 49.
Bundles arranged chronologically backwards, I see, as
yes,
the other bundles have been.
Yes, I think that's right.
Wonderful.
Which also reflects UTJ practice. Whether it's helpful is a different point.
Yes. It's the back of that tab. It's page 49. And although this is annexed to the Upper Tribunal determination that was promulgated on the 18th of May, these are directions that were sent out to the party on the 1st of May. And the relevance of these are that it makes it very clear that at this stage, Upper Tribunal Judge Hanson was not aware and did not think that the 2nd of April submissions existed. And the reason for that is you'll see in his reasoning in paragraphs 2 and 3 of the directions. Perhaps I should invite my lords and my ladies to read paragraphs 2 and 3. In my submission, some matters turn on this.
So the first document to be received was that of the 3rd of April from the Secretary of State.
Yes.
That's the point.
Yes. And then paragraph 4, then followed written submissions received on the 16th of April from the appellant, described as being submissions in reply. Whilst these seek to respond to those provided by the Secretary of State, they are the first detailed submissions made as the making of error of law, and the failure to provide the same first submissions deprive the Secretary of State the opportunity to respond to the same. This is procedurally unfair. And so
So he's got it round his neck, really.
I'm sorry?
He could have. I mean, he's got it round his neck, but he could have imagined that if you were saying you were applying, that you'd have put in something initially, couldn't he?
Although that wouldn't be the way that the directions envisage matters happening. In the same way as the standard directions that follow the presidential guidance note, the first thing that was invited was submissions on the area of law, and then those were sequential. And then, as my learned friend pointed out, slightly quixotically, there was then a non-sequential invitation to anybody who wished to make an application that there ought to be an oral hearing.
Yeah.
So the sequence of events, or shall I say, the way that council approached the sequence of events was correct in terms of the directions. Might not be correct in terms of a matter of logic, but it was what he was asked to do. Now the difficulty here is that there are two things. Firstly, clearly the judge hasn't seen the 2nd of April submission. The Secretary of State clearly had, because in the body of the 3rd of April reply, there are a series of references to those submissions. So, obviously, don't know what was in the judge's mind, but it's difficult to read the 3rd of April submissions without thinking, hang on, what are these a response to? It may simply be for case management reasons, he just didn't delve into the documents, but nevertheless, these directions are clearly reflective of him not having received the 2nd of April submission. As I pointed out earlier, those submissions were both detailed, recasting, and also took an opportunity to take the decision maker to specific aspects of the evidence and of specific submissions.
They were quite long. They were 15, 20 pages.
I don't think it was as long as that. I think they were eight pages.
Oh,
They in fact criticised the grounds of appeal for a lack of precision and concision, and then seek to recast them in a way that
More lengthy.
Yes.
Accordance with the usual practice.
I was going to say classic counsel, but
You can say that.
I'm speaking obviously for myself, but the point is, of course, that just looking at the procedural fairness and how things develop, at this stage the appellant believes and is told that those submissions haven't arrived or haven't been considered, and also the judge is essentially making new directions on the basis that not that they didn't arrive, but they didn't exist, because he hasn't. If you look at the directions he makes at 5.1 Roman numerals 1 to 3 on page 50, having decided that what's happened has been procedurally unfair to the Secretary of State, he then makes provision for her to make further submissions in order to rectify that procedural unfairness, because he's labouring under a misapprehension, because the Secretary of State's already responded to the document that he thinks. That becomes, in my submission, important because of the way he then deals with the substantive decision and the way that he structures that and what references he makes to the documents and which references he doesn't. All of this, of course, informed by the fact that there's no oral hearing. And as I said earlier in my submission, that heightens the responsibility on the judge, irrespective of all of the context of this case, the PGN, HWI. If in the ordinary event of things there's an oral hearing, then the reason there is not, my submission, I'll take you to some learning on the point, is that does heighten the responsibility of the judge to deal with each of the points that are put before him. And in particular, a whole tranche of submissions have to be engaged with in order for the decision to be fair. So there's then some emails between the parties and the tribunal in which the Secretary of State says, in terms, I neither wish nor need to make further submissions, understandably, because I've already made them in response to the submission.
Do we have them in the bundle?
I've been asking for them. My client was represented by a different.
I saw
firm.
that. Yeah.
So we haven't got them. I'm reasonably hopeful we might get them soon, but I have been asking for them for a while.
But is this a fair summary that his solicitors, so your client's solicitors emailed on the 12th of May and on the 18th of May to point out that submissions had been lodged on the 2nd of April, and on the 15th of May the Secretary of State confirmed by email that she had in fact received the submissions on the 2nd of April?
Yes, that's reflected in the pleadings that counsel at the time made. There's no reason to think he was just simply making that up. They must have been based on what did happen. So there's then the series of emails. The next thing that happens after those directions on the 1st of May is in fact, after those emails, is the 18th of May promulgation of the upper tribunal decision in this case. So that's some 2 weeks or so afterwards.
They were promulgated on the 27th of May, but the decision was obviously made on the 18th of May.
You're quite right, Molly. That's correct. The date is the 18th, promulgated on the 27th. That's at tab 6, page 38. And for reasons that I hope become apparent, it's necessary to drill into this decision in a way that one might not ordinarily do so, and that's because if one does that, one can see that, shall we say, this determination does nothing to assuage any concerns that the judge did not have the 2nd of April submissions in mind.
It does nothing to assuage those concerns.
Yes.
Yes.
Can I, just before you get into that, just ask one further question on the background? You very fairly set it out in your skeleton argument on the appeal that there had been a previous determination which was adverse to him. He then, it appears, wrote a number of letters and then made a formal application which was rejected. Were there any steps to remove him in the interim, and if not, why not? I suppose that's for the Secretary of State to answer.
Yes, I don't believe so. I don't know why not. It wouldn't be unusual.
No, I appreciate that, but it does, sometimes make one wonder the importance of deciding all these cases when nothing is ever done about them.
My Lord, all I can say about that is that clearly what had happened is there had been one decision where a judge had very clearly indicated that he had one area of concern, and then this appellant very properly under the appeal system put forward representation.
New materials, yeah.
Yes,
I saw that.
and he was afforded a right of appeal, and then the new appeal was essentially about whether or not that new evidence did fill the gap. That was what it was about. So this decision begins on page 38. I wonder if I could ask you just to perhaps put a pen also in the grounds of appeal at tab 13 as well, because a comparison of the decision and the grounds of appeal is instructive as to what the focus of the judges, or certainly the papers
And what page are the grounds of appeal?
The grounds of appeal are at page 88. So beginning at page 39 of the decision, you'll, and I'll come back in due course to the judge's reasonings for disposing with an oral hearing, paragraphs 2, 3 and 4, but in terms of the substance of the decision, one looks at paragraph 5 onwards. That's in setting out the background to the case. You'll see, I won't dwell on this too much, but effectively if one looks at paragraph 17 of the decision underneath error of law, and then turns back to paragraph 5 of the grounds appeal, page 89, and then one follows paragraph 17 through to paragraph 27 of that decision and compares it to paragraphs 5 through 24 of the grounds. They are very, very similar, even to the extent of the chronology, the way that the language is essentially transposed. They are very, very similar in style and language and indeed structure and order. It's a feature, and I'll give this as an example just because we're here, that if one looks at the decision at paragraph 23, so if I just cite that, the appellant challenges the judge's finding that the 3 money transfers that were before Judge Parks were relatively small amounts.
Sorry, can I just have that paragraph number again, or the page?
It's page 42, paragraph 23.
Yeah.
That paragraph, there's references to the exchange rate between the British pound and Pakistani rupee. Also then reference to Habib bank transfers. Then if one looks at page 92 again, paragraph 20 of the grounds of appeal. You'll see a very similar paragraph. But it's noteworthy then, paragraph 22 of the grounds of appeal, there is a complaint about essentially the illegibility of the meaning of paragraph 39 of the first tier tribunal decision. This is at page 92, paragraph 22. In the judge's decision between in paragraph 23 to 24, that is missed. And you'll see at paragraph 24 of the judge's decision that he then deals with what's said at paragraph 23 of the grounds about the questions that were asked of the witness or the appellant. So paragraph 22 is not transposed and is a feature of part of the case that wasn't dealt with at all. That then goes on. The judge's decision then goes on in a similar way. All the way to paragraphs 25, 26, and 27 on page 43. Again, all referring to the grounds. You'll then see that the next document in time that the judge refers to in this decision, at paragraph 28, is the response to the directions of the Vice President, the third vague. So the obvious point from a structural analysis of the determination is the obvious point to deal with the 2nd of April submissions would be between the grounds of appeal and the respondent's response to those grounds. On any logical view, that would be the place to put it. But what the judge does is deal with the response, but it's the way that the judge frames the response is a response to the earlier directions rather than a response to the submissions of the 2nd of April, which on one view is right. It was a response to the direction, but clearly the idea of the response was to give the Secretary of State an opportunity to respond to the Secretary. There's then a reference at paragraph 30 to the written submissions of the 16th of April, and then transposition of the witness statement that was put in about one of the grounds of appeal. And then the judge refers to paragraph 31 and 32, his reasons for discounting points made about the order. There's reference to the supplementary grounds of appeal, which were the grounds of appeal to the first tier tribunal against the original decision, paragraph 33. And then there is some further reasoning, which we'll have to go back to at some point. But the short point is that nowhere in that decision, at any stage, does he either implicitly or explicitly refer to the 2nd of April submissions. It just doesn't exist. And so, on that ground, my submission is that actually, irrespective of whether or not the PGN is found ultimately to be unlawful, whether JCWI is correctly decided, whether EPL Albania is correctly decided, or even, on one view, whether there was an oral hearing or not, to entirely discount a set of written submissions in a case of this type is an error of law.
Can I just ask one other point on that? The decision at Annex A, the judge appended his directions of the 1st of May. As you've already pointed out, those say in terms, I didn't get anything and it was procedurally unfair, which at least partly supports your submission that he can't have had the 2nd of April ones, otherwise he would have changed that or not appended it to his judgment.
Yes, and that's supported by what the judge says in the first paragraph, which I was going to
Well, sorry to interrupt.
No, not at all. The second paragraph, I should say, which was following the close, page 38. Following the closure of Field House and the adjournment of the UTJ hearing, direction was sent to the parties on the 20th of March, indicating a preliminary view that the area of law hearing was suitable for determination remotely, and providing an opportunity for the parties to respond. A response was received, but not in the terms anticipated by the directions. Accordingly, further directions were issued and sent to the parties on the 12th of May. The copy is sent out to Annex A. On the 14th of May, the respondent's representative emailed UTJ advising the Secretary of State did not wish to file any further submissions. So had the judge realised his error and appreciated that there was this 2nd of April submission, and that in fact that had been overlooked in some way, that would be obviously another place where one might expect him to mention it. But there's nothing in the determination, either by inference or directly, to say that he had any of those in mind. There's then an application by Mr. Hussain through his counsel to appeal to this court made directly to the upper tribunal in accordance with directions. That's at tab 5, page 33. It begins at page, it begins at page 33. And it is perhaps worth noting briefly that this was both an application for permission to appeal to this court, but also an application under Rule 43 for the matter to be set aside because of procedural irregularity. So it was an example of a case where the appellant was seeking to do one or other. And the obvious procedural irregularity that was pointed to was, well, firstly, disposing of an oral hearing, but secondly, on the substantive basis that submissions had been overlooked. And the grounds are set out. Ground one is an argument about the disposal of the oral hearing. And then the fourth paragraph on page 34 complains about the judge's failure to consider material matters and procedural irregularity or procedural unfairness because he failed to, it says, appreciate that the appellant had filed and served written submissions. Sorry, it says realised, but really there's an argument about failure to take into account written submissions. And then there's the last ground across the page on page 35 is, and one might say not unrelated to the other ground, a failure to engage with central aspects of the appellant's case, central aspects of the appellant's criticism of the first-tier tribunal judge's decision. That application went before the same judge, Upper Tribunal Judge Hanson, and he deals on page 30, tab 4, with the grounds challenging the decision to dispense with oral hearing. But just over the page, the paragraph 6, ground 2 asserts the Upper Tribunal committed a procedural error by failing to consider correspondence from the parties. But such a claim has no arguable merit. It was not a requirement to set out each and every aspect of the evidence, but all pleadings and available material was properly considered by the Upper Tribunal. Whilst directions indicated a failure to serve written submissions in accordance with Mr. Osborne's directions, the chronology was clarified at a later stage, leading to all submissions filed being taken into account. There's no arguable merit in the assertion written submissions or evidence were excluded in the decision-making process. Now, there's a couple of things to say about that. Firstly, is there's still no specific mention of the 2nd of April submissions in that decision. Secondly, there's no indication at all as to how the 2nd of April submissions were taken into account or how they were considered in the context of the case as a whole. And thirdly, it's ex post facto reasoning following the promulgation of the decision after an application of submission to appeal to this court. So what I've said in my skeleton is the short point, is that very brief paragraph in a response to an application to appeal to this court cannot save.
Well, what troubles me about that, if I may say so, Mr. Lee, is that this is a judicial decision responding to an express application for permission to appeal on the grounds that the 2nd of April submissions had not been taken into account, and the judge is rejecting that on the grounds that all submissions were taken into account. And I mean, you know, without wishing to heighten the tension in the case, that sounds like a submission that the judge is not being straight.
Well, so I wouldn't. Firstly, I wouldn't, and secondly, don't need to go that far.
No, but I mean, what are you saying?
So
you're saying he was mistaken, or
I'm saying, so all I need to say,
because on one analysis, I mean, that suggests saying I did take it all into account, and that's it.
So you'll see I made 3 submissions on the point. Firstly,
I get the previous ones.
Yes. Yeah. So the fact that a judge doesn't give reason or doesn't engage with the central aspect of the evidence does not necessarily mean that it wasn't before him. But it would still be an error of law, in my submission, to fail to engage with material arguments. I'll very briefly take my lord to some learning on the point in this jurisdiction. So the first point is that, well, if one looks at the determination and in light of the procedure, cannot identify at any stage where the judge has engaged substantially with those submissions, or they've affected his view of the case or informed his analysis of the arguments or evidence in any way, that amounts to an error of law, even if there was some positive evidence that he had them in front of him. Because it's trite to say that. It's a determination must be intelligible. It must give the losing party sufficient information to understand why he or she has lost, notwithstanding arguments that were made in his favour. Not least because, of course, his advisors will want to see if there's a right of appeal on that basis. And if one was to look at this determination and say, well, why did the 2nd of April submissions on X, Y, and Z not make any difference? The only reference the judge makes to it, and even then not specifically to the document, is in the refusal of permission to appeal. So I don't need to, I wouldn't, and I'm not suggesting that in some way the judge is either mistaken or is deliberately sort of being obtuse about the matter. All I'm saying is that one looks at the determination, one looks for a reference to those submissions, either implicitly or explicitly.
But are there points made in the submissions that you say ought to have been dealt with and have not been dealt with?
Yes, I will. That's part of my. Yes, I will take you to some specific examples. But just to dwell on this point, I understand my Lord's concern, but there is also, and the reason I say there's also obviously a difficulty in ex post facto rationale that doesn't say how the submissions were taken into account. And there's also...
Well, I mean, we'd all get in trouble if we didn't do that, because otherwise we'd be all writing judgments that were a mile long. But
the reason I began with this point is that this is all informed, of course, by a change in procedure from what would ordinarily be an oral hearing with, dare I say it, reflexive engagement between the parties and the judge about what submissions are relied on, what the judge is concerned about. I mean, obviously the first thing one would do if one turned up at an oral hearing where the judge had issued directions to say that I haven't received the 2nd of April submissions, first question one would say, well, does my Lord now
the first thing Ms. Kilroy tried to do this morning was to take me through all the documents we'd got, and I summarily dismissed the idea.
My learned friend's instincts were as correct as ever. I mean, the additional feature in this case, of course, was that the judge had identified a document that he didn't have. And it would be very odd if we turned up this morning and having my Lord sent an email the night before saying, well, I don't have a bundle.
No, I mean, but it is normal for judges to sort of recognise they haven't got something when they haven't got it. But there are 2 stages in Judge Hanson's treatment of the matter, when he didn't recognise that he didn't have something but he might have done. And then he says, as you rightly point out, without giving chapter and much verse, I did have it.
Yes, there's not much. I mean, I appreciate my Lord's point about the judgments having to have a finite limit, but one can't simply say, for example, I've considered all the evidence, I've considered all the arguments, and the appeal is dismissed.
You can actually, but your point must have some substance to it, which is that there were parts he didn't deal with at all. That there's material which
I totally agree with that, with one caveat, if I may, which is the context of what's happened here. So, a default position of having an oral hearing is removed for reasons that we understand. There is then a direction for sequential written submissions said to be an adequate replacement for the oral hearing itself. Mm-hmm. So the context of it is that the judge considers...
It's even more important.
Yes, And so I would go so far to say that if this court has any doubt at all as to whether the 2nd of April submissions might have made a difference one way or the other, that's enough. That benefit of that doubt ought to go to the appellant because of the context and because of, I won't go back over it, but all of the learning on the importance of oral advocacy, precisely because it avoids.
Well, no, I think you'd be pushing it a bit of an open door with the idea that if you're replacing oral submissions with written submissions, it's pretty important you have a look at the written submissions.
Yes, but I'd go further, that you engage with them and you demonstrate that you
Well,
because
I mean, it depends what they say, but yes, I mean, obviously if they're substantive, they have to be engaged with.
yes.
I mean, I haven't looked at those. So.
I will. I mean, I may have to do it in the morning, but I will go through. And it's right to say that, as counsel who drafted that document says, they are a recasting of the grounds. But what they represent.
Oh, yeah, we did look at them. I'm sorry.
Yes. Yes.
The document I thought was longer than it was.
Yeah. So what counsel is trying to do, as I said earlier, given the restrictions of the procedure, he is attempting essentially to do what one would do in oral advocacy, which is to say, here are the grounds of appeal.
That's why you made the point about the recasting.
Yes, yes, because it's a bit like saying, well, we're not gonna look at that document, or we're not gonna.
Well, I mean, you would say if the judge went to sleep between 2 o'clock and 3 o'clock, and I regret to say that in past days it happened occasionally, that's not a fair hearing.
Yes.
Irrespective of what was said between 2 and 3 o'clock.
Yes, and if Mr. Waite was to stand up and say, well, Mr. Lee's submissions couldn't have possibly made any difference one way or another, the appellant would still feel quite rum about the idea that I was not heard. And in this way, as I said, that's why I do draw a distinction. I understand why.
Does it go further? I'm sorry to press you on this, but this paragraph 6 really troubles me. Is there any further material that helps us?
No, I can. As my Lord Dingemans mentioned, there's an email exchange which I've been trying to obtain between the Home Office, the appellant's previous solicitors, and the tribunal, which deals with the Home Office's position with regard to not putting in further representation. So you'll note that the direction.
Yeah, but I mean that won't tell us more about whether Judge Hanson really took the 2nd of April submissions into account.
No.
It might help show whether he actually had them, or he had been referred at some point to them.
Yes.
I mean, I suppose another point you make is that this demonstrates the dangers in having written hearings on the papers.
Yes. So the way I put it is it's illustrative of. Illustrative of the dangers.
Yeah.
But it's also informed by that context, in the sense that I say that the phrase anxious scrutiny is used, perhaps abused a lot in this jurisdiction, but
Say that
I would suggest that in this case it's beyond anxious scrutiny. It's suspicion almost that the court ought to look at a suggestion that something hasn't been taken into account very, very.
I suppose you would say that when judges come in and say, I've read all the papers, which is always true in our case.
I for one, always believe that.
But when they say that, if they haven't, then that is anyway at the very least unfortunate.
Yes, I mean it's not as concerning as when judges say they haven't read the papers and then halfway through your submissions you realise they have. But yes, I mean, but there's really 2 points. The first is that, and I'm repeating myself to extent. The first is very important, which is that even if it's not my case, but even if I wasn't able to take you to substantive points within those 2nd of April submissions that were materially different from aspects of the case that were put elsewhere.
No, you say it's a procedural error.
It's a procedural error, and that's informed by this context. We're already in the position where, taking JCWI as correctly decided, we're already in the position where the presidential guidance note is said to lead to a risk of systemic unfairness. We're already there. We point to an aspect of this case where detailed submissions considered to be more precise and concise than the original grounds of appeal were put in, and all of the evidence, or let me put it more neutrally, there's no indication of any engagement with those submissions in any of the material.
I mean, not wishing to be unkind, the drafting of clause paragraph 6 is quite mercurial, because it starts by talking about correspondence and then talks about submissions. And you may, but I don't entirely understand what the third sentence is intended to mean. While directions issued indicated a failure to serve written submissions in accordance with Mr. Ogleton's directions, don't really see why directions issued indicated that.
No.
Leading to all, but the chronology was clarified at a later date, when, leading to all submissions filed being taken into account. I mean, it's mercurial at the best.
It's also because it's ambiguous, because
Well,
if
it's ambiguous, yeah.
if one looks at that final sentence, leading to all submissions filed being taken into account, it still doesn't answer the question as to whether the judge considered that those 2nd of April submissions had in fact been filed. I mean,
Can we just look, which page is ground 2? Sorry, but you did tell us. Well, he's talking about ground 2.
Yes, so
this is what he's addressing.
He's responding to the application for permission to appeal to this court, which is at page 33.
Yeah, sure. Can I just try and, in the context of paragraph 6, just
Yes.
see if I'm right about how it links up, or I think it links up.
Yes.
So we have at page 38, in the decision and reasons which were promulgated, at paragraph 2 that you've already taken us to. So with the 27th of May, so this is after the correspondence that you haven't been able to put your hand to.
Yeah.
So at that stage, what the judge said, response received but not in the terms anticipated, so further directions were issued, sent to the parties on the 12th, copy of Annex A. Doesn't tell us at that stage what the response not in the terms were, but we can see that, I think, if we turn to page 50 when we look at the annex.
Yes.
Because the paragraph 4, which starts beginning at the page 4, followed written submission 16th of April, seek to respond. They're the first detailed submissions made as to the making of an error of law. So clearly we collect from the promulgated decision of the 27th of May
Yes.
that the judge is referring, it has not referred to the 2nd of April.
Yes.
Right, so
Yes.
then I turn to paragraph 6, which starts ground 2 asserts. Whilst directions issued indicated failure to serve written submissions in accordance with the directions, so that must be Annex A.
Yes.
The chronology was clarified at a later stage. Now, this decision is dated the 3rd of August. Is there anything you can take us to between the 27th of May and the 3rd of August which suggest that the chronology had been clarified?
Well, there's no. No. I can check overnight, but I haven't seen any.
So that takes us back to your submission that based on what the judge wrote himself in his decision, together with his annex, he's mistaken in what he says in paragraph 6 about ground 2.
Yes, and even if he was, so I certainly would adopt that formulation, but my submission also goes further, which is even if paragraph 6 was correct.
I understand
yes.
that, but I'm just was trying, because concerned about it. I just wanted to track it through for myself to make sure that I was
Yes, I
clear
haven't
that
said.
that, on the face of it, can't be right.
No, I haven't seen any. I mean, it would be unusual for there to be post-determination submissions on that point that weren't then referred to in the permission to appeal application or indeed in the decision. There's no exchange of correspondence that I've seen. I will double check the point overnight, my lady, but no, I don't think there is.
Mr. Lee, please check it overnight. I've not noticed the time, but
I'm sorry.
Really must be somewhere else and we must adjourn. But we're all right for time as far as your submissions are concerned.
My lord, yes, I'm borrowing from my own time in reply, I think, so I'm hoping that it'll be all right.
Well, you've still got half an hour, I think, unborrowed. Yeah. Okay, 10:30 in the morning.